Well, good morning, everyone, and very much warmly welcome you to the 21st meeting of the Referendum Scotland Bill Committee. Can I remind everyone to please switch off their mobile phones? That would be very helpful. No apologies have been received, and obviously I welcome Lewis MacDonald and Drew Smith to their first committee meeting this morning. Very much warm welcome to you. But I think we should also record our thanks to the contribution that had been made by James Kelly and Patricia Ferguson when they were committee members. Our first item on the agenda this morning is the Declaration of Interests. So therefore, in accordance with Section 3 of the Code of Conduct, I invite the new members of the committee to declare any interest they may have relevant to the remit of the committee.
No relevant interest to declare.
No relevant interest, Convener.
Thank you very much, both. That takes us to the choice of Deputy Convener, which is the second item of business that we have today, to replace James Kelly. The Parliament's agreed that only members of the Labour Party are eligible for nomination as Deputy Convener of this committee. I therefore invite the Labour members to indicate which one will be the nominee.
Convener, can I volunteer to nominate Lewis MacDonald?
Lewis, I presume you're going to accept that honour.
I'm happy to accept it.
I therefore invite the committee to agree that Lewis MacDonald becomes the Deputy Convener. Thank you very much. The third item today on the agenda is Stage 2 of the Scottish Independence Referendum Bill, and I welcome Nicola Sturgeon, the Deputy First Minister, and her officials to the proceedings. Just to go through the process, reminding everybody where we're at, everyone should have with them a copy of the bill as introduced, the marshalled list of amendments and the groupings, which sets out the amendments in order which they will be debated. There will be one debate in each group of amendments. I will call the member who lodged the first amendment in that group to speak to and move that amendment and to speak to all other amendments in the group. I'll call the Deputy First Minister to speak on every group. Other members who have lodged amendments in the group but who also wish to speak should indicate that by catching my attention in the usual way. At the end of each debate, the mover of the lead amendment in the group will have an opportunity to wind up. And as we know, only members of the committee are allowed to vote in any division. It's important that members keep their hands clearly raised until the clerk has recorded their names, and I'm going to make sure they've got time to do that. I think I probably rushed it a bit the last time. As well as disposing of amendments, the committee is required to consider formally each question and schedule of the bill and the long title, so I'll put the question on each at the appropriate point. Now, given the number of amendments, it seems certain that the committee will need 2 meetings to complete Stage 2. My aim today, therefore, is to get through as many as possible up to Group 15. However, I don't intend to go beyond that point today, and we'll let Liam MacArthur know that yesterday evening so that he wouldn't have to be here at the proceedings of the committee on this occasion, but obviously can turn up next week. With that said, I think we should just get on now with the proceedings. And the first question is that Section 1 be agreed to. Are we all agreed? That takes us to calling Amendment 4 in the name of the Deputy First Minister, group with Amendment 5, 22 and 23. Deputy First Minister to move the amendment and to speak to all amendments in the group.
Thanks, Convener. These amendments relate to the positioning of the official mark on the ballot paper. The original drafting of the bill provided that the mark should appear on the back of the ballot paper. This was raised during Stage 1 evidence, and I explained then to the committee that the reason for putting the official mark on the back was to enable voters to demonstrate to polling staff that their ballot papers were genuine without revealing how they had voted. However, after discussions with returning officers about their very clear preference for moving the official mark to the front of the ballot paper, I have agreed to bring forward these amendments to move the position of the official mark. I hope that these amendments will increase the efficiency of the count while maintaining the security of ballot and protecting voters' identity. So I move Amendment 4.
Seen any indication of anyone else wishing to speak in this group? So I guess the Deputy First Minister won't need to wind up in these circumstances. Therefore, the question is that Amendment 4 be agreed to. Are we all agreed? Call Amendment 5 in the name of the Deputy First Minister. Already have debated with Amendment 4. Deputy First Minister to move formally.
Moved.
The question is that Amendment 5 be agreed to. Are we all agreed? Agreed. The question is that Schedule 1 be agreed to. Are we all agreed? Agreed. The question is that Section 2 be agreed to. Are we all agreed? Yes. Okay. I call Amendment 6 in the name of the Deputy First Minister in a group of its own Deputy First Minister to move and to speak to the amendment.
Thanks, Convener. This amendment relates to an issue that has been discussed extensively by the committee previously, and that is the position of children of service personnel. Committee members are very familiar with the issue, and I've been very clear throughout all of the discussions we've had prior to today that the Government is committed to ensuring that every young person who should be entitled to vote in the referendum is able to exercise their entitlement to vote. However, unlike the position with regard to spouses or civil partners, existing UK legislation doesn't allow the children of those with a service qualification to themselves register to vote by making a service declaration. As the voting age has been lowered to 16 and 16 and 17-year-olds are of course more likely to still reside with their parents, it's possible that this could have the effect of preventing some young people living outside of Scotland to be with parents in the services from registering to vote. Now, I've made clear in my previous correspondence with the committee that the number of young people so affected is likely to be extremely small, but nevertheless, I think it is important that they are afforded the same opportunity to vote in the referendum as their peers whose parents are residing here in Scotland. So we've been committed to finding a solution to enable such young people to register to vote. I'm therefore pleased to bring this amendment, which is the product of very constructive discussions with electoral registration officers and the Electoral Commission, and I want to thank them for their very positive and pragmatic contributions. Amendment 6 amends the Scottish Independence Referendum Franchise Act to provide a mechanism for young people aged 16 or 17 on the date of the referendum to register to vote in the referendum if they can demonstrate that they would be resident in Scotland were it not for the fact that they reside at a place to be with a parent or guardian who has a service qualification. Such young people would be included in the register of young voters, assuming, of course, that they meet all of the other requirements for registration in that register. Under the terms of the amendment, the young person will make their own service declaration in the form of which will be largely the same as for those currently able to make service declarations. The declaration will be a one-off. It will apply only to the referendum. Entitlement to vote in the referendum by this method will be subject to residence criteria, and completely in line with normal practice, applications will be for electoral registration officers to determine, and such decisions will depend, of course, upon the circumstances of individual cases. As I've already indicated to the committee, officials have had initial discussions with the Electoral Commission about how best to publicise these arrangements, and subject to the committee's agreement to the amendment today, I will report back to the committee on the outcome of these discussions before stage 3. I'm confident that these proposals present a workable and practical solution to an issue that has been identified by members of this committee. I would repeat that I think the numbers affected here are likely to be very small, but nevertheless, even if it is only 1 or 2 people, it is important that we do everything we can to ensure that young voters are able to participate in the referendum. I think this amendment achieves that, and I therefore move Amendment 6.
Okay, thank you very much. Drew?
Thank you, Convener. First of all, just to welcome the Deputy First Minister and officials' efforts on that. I think we've come to a good solution for these 16 and 17-year-olds. One question that has been raised with me is the position of 18-year-olds who might find themselves still residing with a parent or guardian in a service base or something similar. I presume from the Deputy First Minister's letter to the committee that because we're only able to amend the register of young voters, that there wouldn't be anything that we could do to assist those people, but I just wanted to seek some clarity from her that that is the case. And also, could I just really inquire, Convener, around the balance of whose responsibility it is to promote the right to vote to these 16 and 17-year-olds, whether that is a balance between the Electoral Commission and the MOD as the employers, and whether she's got any more information about that she was able to share and sum it up.
Okay, before we go back to the Deputy First Minister, does anybody else want to come in?
Could I just come in briefly? I'd be interested to hear what the Deputy First Minister has to say, but I think we had touched on this issue in our earlier deliberations, and of course the voting system for 18-year-olds is set by the UK Government. It's the Representation of the People's Act, and I think we had already identified that that was where the responsibility for that issue lay, but I'm interested to hear the discussion.
Okay, anybody else before I let the Deputy First Minister respond? Deputy First Minister.
On Smith's first point, I think his own analysis of the situation is correct. 18-year-olds in these circumstances would be termed overseas voters. Overseas voters are not on the local government register, and of course it's the local government register that's been used for the referendum, so that is the position there, and we're not able to alter that. In terms of the second point about promoting this, I think the MOD does have a big role to play and a responsibility, not just to promote the arrangements for registration to children of service personnel, but to promote the arrangements generally to service personnel, to make sure that we are challenging a myth that has been perpetuated in some quarters, that service personnel won't, if they're not in Scotland, will not have the right to vote in the referendum, which is clearly not the case. So, as I said in my opening remarks on this amendment, we're discussing the promotion of these arrangements with the Electoral Commission, and I'm happy that we feedback on that, and also factor into that feedback any input that the MOD might have to that.
Thank you, Deputy First Minister. Therefore, the question now is that Amendment 6 be agreed to. Are we all agreed? Yes. The question is that Sections 3 be agreed to. Are we all agreed? I now call Amendment 7 in the name of the Deputy First Minister, grouped with Amendments 8, 9, 10, 13, 14, 15, 16, 24, 25, 108 and 109. Deputy First Minister to move Amendment 7, speak to all other amendments in the group.
Thanks, Convener. These amendments relate to absent voting, again an issue that was raised at stage 1 of the bill, and indeed an issue that was raised in the stage 1 debate in the Chamber. Members will be aware that the bill currently provides that the deadline for an application to vote by proxy is 5 p.m. on the 11th working day before the poll. The intention of that was to standardise the cut-off dates that run across Schedule 2 to the bill. Given that the date of the referendum is already known and is known far in advance, it was felt that a cut-off date 11 days before the poll would give individuals more than sufficient notice to decide how they wish to vote. However, both the Electoral Commission and the electoral administrators have raised this as a potential issue, requesting that the bill should be amended in line with the usual practice in the Scottish Parliament and local government elections, so that the cut-off date for applications to vote by proxy in person should be 5 p.m. on the 6th day before the date of the poll, to provide another method of voting for those who can't vote in person on polling day but are too late to apply to vote by post. We have very carefully considered the best way forward here to amend the bill that will meet the concerns raised by electoral administrators and by the Commission, but to do so in a proportionate way and in a way that best meets those concerns. Changing the bill to move the proxy application deadline to the 6th day before the poll would require extensive amendment to Schedule 2, which might give rise to some unintended effects. But in addition to that, and perhaps more saliently, we don't believe that it would necessarily address the specific concerns raised, given that doing that wouldn't help anyone whose plans unexpectedly changed after the 6-day cut-off period. And the Icelandic volcano situation has been raised as the example of why this needs to change. Changing the cut-off date to 6 days before wouldn't necessarily help people caught up in a situation like that. So what we propose today, instead of amending the bill along these lines, is to extend the eligibility for making an emergency proxy vote. This would achieve the same end, and I think it would more appropriately address the concerns expressed, given that for many people unexpectedly called away from home or prevented from returning home, this might happen after the suggested 6-day cut-off. The bill currently provides for people who have suffered a disability after the cut-off date to appoint a proxy to vote for them in person up until 5 p.m. on the day of the referendum. As part of its suggestions for amending the absent voting arrangements, the Electoral Commission suggested that the bill be amended to extend eligibility to appoint an emergency proxy to those who have been called away unexpectedly for occupation, service or employment reasons. We propose to extend that slightly further to include any individual who is unavoidably and unforeseeably away from home on polling day. That will enable some people to apply to vote by proxy who would otherwise be unable to participate in the referendum. The bill currently provides that emergency proxy applications on the grounds of disability require no independent verification. However, there have been some concerns about that expressed by EROs about the potential for misuse. So we are also proposing today to introduce requirements for attestation for all emergency proxy applications. Any person making a false statement or providing false information in an application for an emergency proxy vote, as indeed with any postal or proxy vote application would be committing an offence under paragraph 4 of Schedule 7 to the bill if they did try to gain a vote to which they were not entitled or to deprive another person of such a vote. And such an offence is a corrupt practice that carries a maximum penalty of 2 years imprisonment, an unlimited fine, or both. We also propose to amend the bill so that counting officers are able to issue postal ballot papers before the cut-off date when it's practicable to do so, and expand the offence provisions along with other amendments to prevent voters from attempting to vote by proxy as well as voting in person or by post. So we consider the changes we propose to make to the bill in this area at stage 2 will help to make sure that we're putting the interests of the voter first here by avoiding as far as it's possible to do any unnecessary barriers to voting, but doing that in a way that also helps us to ensure that the referendum is conducted to the highest possible standards of probity. So I hope members will think that we've arrived at the right balance here, and I move Amendment 7.
Lewis MacDonald.
Thank you very much. As the Deputy First Minister has indicated, this is one of the areas where the bill, as introduced, is not wholly in line with existing best practice, and where a number of the government's proposed amendments are not supported by the Electoral Commission. And so I'll focus my comments on those amendments, in particular numbers 7 to 10 and 14 and 16, most of which have been commented on directly by the Electoral Commission this week. I think that best context in this practice should be to follow as closely as possible the existing technical rules as to who can vote, how they can vote, in what circumstances. And I welcome the fact that in the main the bill meets that standards, and that the government has, in a number of areas, moved its position in order to meet that standard. However, I believe that for proxy votes it does not. Where normal practice, as the Deputy First Minister has indicated, is that the deadline for applying should be 6 working days before the poll, in this case the 10th of September next year, the provision in the bill is for this deadline for ordinary proxy votes to be a week earlier, on the 3rd of September. That remains the case in spite of these amendments. The Electoral Commission has affirmed that it wants to see that changed to the 10th of September, and I would therefore ask why ministers have not proposed to make that amendment at this stage, and whether they will revisit this at the next stage. Those who apply for an emergency proxy vote, which is the provision that the Deputy First Minister has outlined, after the 3rd of September, will face a new requirement that their application should have a supporting attestation from their employer or another person. That's reasonable for very late applications, despite the inconvenience, because of the need to prevent fraud. But for those who apply for a proxy vote between the 3rd and the 10th of September, who under existing practice would simply be applying for an ordinary proxy vote, they are now facing an additional inconvenience, which represents an additional disadvantage compared with existing best practice at elections and referendums. I haven't heard a good reason why the ordinary proxy vote date cannot be moved. The Deputy First Minister mentioned that there might be consequential requirements for amendments to Schedule 2. Well, I think she has already shown a willingness in the area of the list of offences to make significant, substantial, consequential amendments in order to achieve the desired outcome, and I think she should look again at that area. Under the Government's amendments, emergency proxy votes are now to be available where voters find out late they are away from home or unable to vote in person for work reasons, but not for voters unable to vote in person for reasons that keep them at home caring for family members. That again appears to be at variance with the approach suggested by the Commission. And again, it's an area where I would ask the Government to think again. Finally, Convener, in this group, the Electoral Commission also raises questions about Amendments 14 to 16. They make provision for cancelling postal votes where the voters in question then apply for proxy votes, but do not make any provision where, for example, a postal vote is cancelled because the voter decides to vote in person, nor does it require the ERO to notify the counting officer when a proxy vote has been granted to someone who already has a postal vote. So if the Electoral Commission says that those things should be spelled out in the bill, I'm inclined to believe them, and I wonder whether the Minister will tell us whether she agrees with them also, and if so, will she bring forward further amendments in the area of Amendments 14 to 16 at a later stage.
Stuart Maxwell has indicated he also wants to contribute.
Thank you, Convener. I very much welcome the shift that the Government's made in this area. I think it is very welcome. I do very much accept the logic which states that, you know, if you have a volcano erupting, it doesn't necessarily want to erupt between the 11th and 6th day before a poll. It may well want to erupt between the 6th and the actual polling day itself. So that the shifting that day itself doesn't actually change the emergency situation in place. And I think the procedure that's been suggested in order to allow people to access emergency proxy is a very sensible one, and the fact that that's also been widened to include a number of other groups, I think, is extremely welcome as well. However, I do accept what the Deputy First Minister says, and I hope she'll expand on this to explain further the detail of why the level of amendments required, which I think she said would be extensive to make the shift from 11 to 6 days. And what the unintended... I know that you might not know what they are, but clearly, if there's a series of amendments at this stage, they could indeed have unintended consequences, which we're unaware of. I am concerned if there would be large-scale amendments to Schedule 2 at this stage, because we have been very, very careful to ensure that we get a bill that we can all support, that is of the gold standard, that meets the criteria that we're after and that the people of Scotland are after. Major changes that may cause a problem further down the line, I would be very concerned to take on at this stage, and therefore I would welcome further explanation on that. But I accept that there is a risk there, and at this stage certainly wouldn't be keen to take on that risk.
Does anyone else wish to contribute at this stage? Patrick Harvey.
I think just to echo some of the points that were made earlier, I would just welcome a general indication from the Deputy First Minister whether the amendments that we're seeing at Stage 2 are, if you like, a work in progress, whether there's a general intention to develop this section further at Stage 3, or if what we're being asked to approve today is the kind of final draft, if you like. A general indication along those lines would be helpful.
Does anyone else wish to contribute? Deputy First Minister.
I'll pick up on Patrick Harvey's point first. I mean, I'd remain open to further discussions here if there are further amendments that people want to put forward. I mean, for example, and this goes to the latter part of Lewis MacDonald's comments, like I think members of the Bill Committee, we received the Electoral Commission's briefing note fairly late last night, so there's some points in there that we want to have further discussions with them about, and we'd be happy to report back on these discussions. They may give rise to further amendments before Stage 3. So I'm, as I am in all of these things, open-minded to further suggestions that might come forward, and I'm happy to take on board the points that have been made by members of the committee and have further discussions around this. What we've been trying to do, though, and continue to try to do, is strike the right balance between recognising an issue of people for unforeseeable reasons being unable to apply in time for a postal or a proxy vote under the deadline set down in this bill, and giving them the ability to nevertheless retain the right to vote through another mechanism, but to do so in a way that is proportionate. I mean, I said earlier on that amending the bill in the way originally recommended by the Electoral Commission would be very complex. And just to give a bit more detail about that, in order that this bill stays within devolved competence, which members will appreciate it has to do, the scheme in the bill differs in some ways from other electoral legislation. In certain areas, including the absent voting provisions, the bill and the previous version of the bill, which was issued for consultation, is drafted to reflect the intention of measures in legislation elsewhere, but it uses different drafting in order to keep the bill within devolved competence. So the effect of that is we can't simply replicate UK electoral law in the relevant parts of this bill. So changing the bill to move the proxy application deadline to the 6th working day before the poll would require really extensive amendment to Schedule 2 in our bill, and that may have unintended consequences. Now, with the definition of unintended consequences is you can't always say what they might be. If you knew what they might be, then you'd be able to avoid them happening. But the complexity of the amendments that would be required there would introduce a degree of risk in this bill that I would agree with Stuart Maxwell is not something we should do at this stage. But nevertheless, I will continue to have discussions to see if there's further steps that we can take before Stage 3. I would repeat the earlier point that was made, in that in terms of the people that would benefit from these provisions, simply changing the cut-off date from 11 days to 6 days is not necessarily going to help somebody who finds themselves the day before the poll called away for work reasons or unavoidably detained and not able to get back in time. So this actually, I think, for people in those circumstances provides not just a solution that makes it technically more manageable for the government and for those scrutinising this bill, but actually makes it more practically effective for the people who might want to make use of these provisions. So I would ask members to support these amendments here today, but give an undertaking that I'm happy to have further discussions and see if there are further amendments that might be possible to make in advance of stage 3, particularly around some of the points in the Electoral Commission's briefing last night that we want to move further on.
Thank you, Deputy First Minister. The question, therefore, is that Amendment 7 be agreed to. Are we all agreed?
No.
Okay, in that case, we'll proceed to a vote on Amendment 7. Those in favour, please raise their hand. Okay. Those against, please show. And those who wish to abstain, please show. The result, therefore, in these circumstances is... let's make sure I get this right. Okay. In favour, agreed to 9. Those abstaining, 2. Therefore, the amendment is agreed to. I therefore call amendments 8, 9 and 10, all in the name of the Deputy First Minister and all previously debated. And I invite the First Minister to move amendments 8 to 10 en bloc.
Moved.
We'll have a go anyway. I ask whether any member objects to a single question being put on these amendments.
We would be happy to abstain on them en bloc if that suits the convener's purposes.
Okay. In that case, I've got to put the question on all 3 amendments, so I have to. So we can't do an abstention on block, unfortunately. Therefore, on Amendment 8, can I okay, so I can put 8, 9 and 10 together. Right, okay, in that case. En bloc, 8, 9 and 10. Those in favour, please show. Those against? And those abstaining? Those in favour agreed to 9. Those abstaining 2. Therefore, the amendment is agreed to. Amendments are agreed to. Okay, that now takes us to call Amendment 11 in the name of the Deputy First Minister, grouped with amendments 12, 21, 26 and 106. The Deputy First Minister to move Amendment 11 and speak to all amendments in the group.
Thanks. Amendments 11, 12 and 106 in my name are technical amendments which arise directly from requests made to us by electoral administrators to standardise our provisions about the computation of time with the provisions in other electoral legislation. There are several points in the bill that require the calculation of a date. For example, Schedule 3, Paragraph 1, subsection 1 states that the counting officer must publish notice of the referendum not later than the 25th day before the date of the referendum. The bill provides a list of days which are to be disregarded for the purposes of calculating such dates. Our original policy decision was not to include days appointed for Thanksgiving or mourning from this list, as the referendum date will be known well in advance, and so any such dates could be absorbed into the timetable. However, the Electoral Commission and electoral administrators have strong views about inclusion for the purposes of consistency with existing legislation, and so we've decided to bring forward amendments to allow such days to be disregarded for the purposes of computation of time. These amendments take account of the views of key stakeholders and it will bring the bill into line with existing legislation. I therefore commend them to the committee, and on the same grounds that I've just given for supporting my own amendments, can I indicate at the outset that I'm also content to support Annabel Goldie's Amendment 21 and Amendment 26, and I move Amendment 11.
Thank you very much. Annabel Goldie to speak to Amendment 21 and other amendments in the group.
Yes, thank you, Convener. I might just mention I registered an interest which is de minimis but unusual. The Law Society gave me a lift in a taxi for which the Law Society paid because I was accompanying a gentleman who was coming here for a meeting, Convener. So in the circumstances I've put that in the register of interest because these amendments do emanate from the Law Society of Scotland and they're very much in the same theme as those to which the Deputy First Minister referred. Amendment number 21 quite simply ensures that within the bill, the days of public thanksgiving or mourning are disregarded when calculating the deadline for publication of the referendum notice. And the reason is that Rule 1.2 provides that certain days are to be disregarded. These include Saturdays, Sundays, Christmas Eve or Christmas Day or bank holidays. And in the referendum rules under the Parliamentary Voting System and Constituencies Act 2011, Schedule 2, Part 1, Rule 2(1)(c) included a provision that any day appointed as a day of public thanksgiving or mourning should be disregarded. It is simply to achieve consistency, Convener, avoid any ambiguity or doubt and have it on the face of the bill what the arrangements are. 26 is in very similar vein. Again, it is to ensure that days of public thanksgiving or mourning are disregarded when calculating the deadline for notification of a polling or counting agent's appointment. And the rationale is, as I've previously described, Rule 14.5 provides for certain days to be disregarded in the calculation of that time period, but it doesn't include days allocated to public mourning or Thanksgiving. And this is just to ensure consistency with Schedule 3, Rule 1, that I propose this should be incorporated in the bill. And to reassure members, I have sought clarification from the bill team, and I am told that just as in the Interpretation Act, the masculine used to embrace the feminine, which I thought was a very nice concept, I am told that although singular, does embrace the plural if there is more than one day. So just to reassure members on that front.
Okay, thank you very much. I'm glad you made that point clear at the end. Any other members wish to contribute on this particular grouping? Okay, Deputy First Minister, do you wish to wind up, or are you...
Just to thank Annabel Goldie for that welcome clarification at the end of her contribution.
The question, therefore, is that Amendment 11 be agreed to. Are we all agreed? I call Amendments 12, 13, 14, 15 and 16, all in the name of the Deputy First Minister and all previously debated, and invite the Deputy First Minister to move Amendments 12 to 16 en bloc.
Moved.
And I ask whether any member objects to a single question being put on these amendments.
12 to 16, I would object to those being put on block.
Okay, so I'll need to go through them one by one in that case. I therefore call Amendment... The question is Amendment 12 be agreed to. All agreed?
Yeah.
Yes.
The question is Amendment 13 be agreed to. Are we all agreed?
Yes.
The question is Amendment 14 be agreed to. Are we all agreed?
No.
No. Okay. In that case, those in favour of Amendment 14, please show. Those opposed and those abstaining. Therefore, in favour and agreed to 9, abstaining 2. Therefore, the amendment is agreed to. The question is that Amendment 15 be agreed to. Are we all agreed? Yes. The question is that Amendment 16 be agreed to. Are we all agreed? No. No. Okay. In that case, those in favour of Amendment 16, please show. Those against? Those abstaining? Go. In these circumstances, those in favour, 9 agreed to. There are none who disagree and 2 abstaining. Therefore, the amendment is agreed to. That now takes us to call Amendment 17 in the Deputy First Minister and a group of its own. Deputy First Minister to speak and to move Amendment 17.
Paragraphs 46 and 48 of Schedule 2 provide that counting officers and the designated organisations are entitled to receive copies of certain registration documents relating to the polling list to enable them to fulfil their respective roles and responsibilities under the bill. Paragraph 53(1) requires secure destruction of these documents within 1 year of the referendum. Paragraph 49 also provides that permitted participants are entitled to receive, for the purposes of the referendum, a copy of the register of local government electors, any updates to that register and associated lists, but there's currently no requirement in the bill for these to be destroyed. So this technical amendment adds the copies of the local government register and related documents to the registration documents which must be destroyed within 1 year of the referendum. I move Amendment 17.
Thank you. Any other members wish to contribute to this? Okay, in that case, Deputy First Minister won't be wishing to wind up. The question is that Amendment 17 be agreed to or well agreed. The question is that Schedule 2 be agreed to or well agreed. I call therefore Amendment 18 in the name of Annabel Goldie in a group of its own. Annabel Goldie to move and to speak to Amendment 18.
Yes, thank you, Convener. This deals with Section 4 of the Act, which covers the Chief Counting Officer. And the effect of the amendment is to clarify the basis on which a Chief Counting Officer could be removed. Section 4 obviously requires Scottish ministers to appoint a Chief Counting Officer for the referendum, and logically Section 4, subsection 5 allows Scottish ministers to remove the Chief Counting Officer if they are satisfied that he or she is unable to perform his or her functions by reason of any physical or mental illness or disability. Now, this provision is different from the provisions of Section 5, which covers other counting officers, and that provision actually allows a Chief Counting Officer to remove a counting officer from office if he or she is satisfied that counting officer is for any reason unable to perform the counting officer's functions. And so it's simply to expand the grounds of removal for the Chief Counting Officer with particular reference to including the conviction of the Chief Counting Officer, because I think it would be both very unfortunate and inappropriate for the Chief Counting Officer. I don't think it will happen, but I think we have to legislate to anticipate anything. It would be inappropriate for the Chief Counting Officer to be convicted of an offence following his or her appointment and for him or her to remain in post. And this amendment is simply to ensure that specifically Scottish ministers are empowered to take appropriate action in that unforeseen and perhaps unlikely, but certainly a very unwelcome event.
Any other member wish to contribute? Deputy First Minister.
My starting point in this is that the Chief Counting Officer should be and should seem to be seen to be independent of government, and I think because of that it's right that the reasons for removing the Chief Counting Officer are limited. That's why the bill, as originally drafted, restricted the power of removal to situations where the Chief Counting Officer couldn't perform his or her duties by reason of physical or mental illness or disability. This amendment makes it clear that Scottish ministers may remove the Chief Counting Officer from office if the post holder is convicted of a criminal offence. And having heard Annabel Goldie's introduction of this amendment today, I'm minded to support this amendment and would encourage members to do likewise.
Annabel Goldie, when you're winding up, would you also move? Because I don't think you moved when you...
Yes, I thank the Deputy First Minister for clarifying the Scottish Government's position, which is helpful, and I formally move the amendment in my name.
Very much. The question is that Amendment 18 be agreed to. Have we all agreed? Yes. The question is that Section 4 be agreed to. Have we all agreed? Yes. The question is that Sections 5 and 6 be agreed to. Have we all agreed? Yes. I now call Amendment 19 in the name of the Deputy First Minister, group with Amendment 20. For Deputy First Minister to move Amendment 19 and speak to both amendments in the group.
Conveners, it currently stands Section 7 of the bill allows the Chief Counting Officer and Accounting Officer to correct their own errors and those of various relevant persons listed in Section 7.3 of the bill, such as registration officers and those who assist them. Electoral professionals have pointed out that the bill doesn't specifically mention deputies of the Chief Counting Officer or counting officers. While it might be implicit in the bill as introduced that these officers would correct errors of deputies, our amendments seek to put the position beyond any doubt. Amendments 19 and 20 to Section 7 of the bill insert reference to the deputies of both officers and place beyond doubt their power to correct errors made by their own deputies, and in the case of the Chief Counting Officer, the deputies of counting officers. These are technical amendments, I think, and I would move Amendment 19.
Okay, any other members wishing to contribute? No other members to contribute. Deputy First Minister won't wish to wind up. The question, therefore, is Amendment 19 be agreed to. Have all agreed? Agreed. I call Amendment 20 in the name of the Deputy First Minister, already debated with Amendment 19. Deputy First Minister to formally move.
Moved.
The question is that Amendment 20 be agreed to. Have all agreed? Agreed. The question is that Section 6 be agreed to. Are we all agreed? Sorry, question Section 7. Apologies. That sections. that 7 be agreed to? Are we all agreed? The question is that sections 8 and 9 be agreed to. Are we all agreed? I call Amendment 21 in the name of Annabel Goldie, already debated with Amendment 11. Annabel Goldie to move or not move?
Moved.
The question is that Amendment 21 be agreed to. Are we all agreed? Yeah. I call Amendments 22, 23, 24 and 25, all in the name of the Deputy First Minister and all previously debated. I invite the Deputy First Minister to move Amendments 22 to 25 en bloc.
Moved.
Ask whether any member objects to a single question being put on these amendments. If no member objects, the question is that Amendment 22 to 25 be agreed. Are we all agreed? I call Amendment 26 in the name of Annabel Goldie, already debated with Amendment 11. Annabel Goldie to move or not? The question is that Amendment 26 be agreed to. Are we all agreed? I call Amendment 27 in the name of Annabel Goldie in a group of its own. Annabel Goldie to move and to speak to amendment.
Yes, thank you, Convener. This concerns a section of the bill devoted to removal of disorderly persons from polling stations. And the bill as currently drafted does give the presiding officer in the polling station, he or she may order the person to be removed from the polling station. But if someone is creating a rumpus, being exceedingly difficult, distracting other people from legitimately participating in their lawful exercise of their lawful franchise, then it could be very tiresome if the presiding officer felt inhibited in the absence of clarity of the bill. And quite simply, the amendment proposes the insertion of the word immediately, so that the presiding officer is explicitly empowered in such a situation to do what he or she thinks fit. And that is the effect of the amendment.
Okay, any other members wish to contribute? And before others do, would you move that as well at this stage?
Moved.
Yeah. Anybody else wish to contribute? Deputy First Minister.
Thank you, Convener. This amendment confirms that a person causing problems in a polling station should be removed immediately, and still, unless they still have to vote and wish to do so, we're content to support the amendment on the grounds that it will help to provide some additional clarification about the powers of presiding officers to keep order in polling stations.
Annabel Goldie, do you wish to wind up?
Nothing more. Thank the Deputy First Minister for her support.
Okay. The question is that Amendment 27 be agreed to. Have all agreed? I call Amendment 28 in the name of the Deputy First Minister in a group of its own. Deputy First Minister to move and to speak to the amendment.
Amendment 28 relates to attendance at the counting of votes. It's obviously an important part of any election or referendum that the counting of votes is carried out transparently. Paragraph 29 of Schedule 3 therefore sets out those who are entitled to attend the counting of votes. Counting officers need to notify interested parties of the timing and location of that count to allow them to attend. Paragraph 29(2) currently provides that they should do that by publishing notice of the time and location of the count. Electoral administrators have expressed concerns that this might be taken to imply that they must post a public notice and that this could have implications for the general management of the count. The committee subsequently raised this issue in its Stage 1 report. To address the concerns of electoral administrators and in line with my response to the Stage 1 report, Amendment 28 amends paragraph 29(2) to make it clear that counting officers need only notify the Chief Counting Officer, the referendum agents appointed for the local area and any counting agents appointed to attend the count. And the amendment brings the bill into line with existing electoral legislation which doesn't require notice of the count to be posted publicly. And with those comments I move Amendment 28.
Anyone else to contribute? Okay. The Deputy First Minister won't wish to wind up. The question is that Amendment 28 be agreed to. Are we all agreed? I call Amendment 29 in the name of Annabel Goldie and a group of its own. Annabel Goldie to move and to speak to the amendment.
Yes, thank you, Convener. This is a more technical point, and it concerns decisions on ballot papers as provided for in Schedule 3. And the provision in Schedule 3 at paragraph 33 simply says the decision of the counting officer on any question arising in respect of a ballot paper is final. But in fact, section 31 of the bill does anticipate the competence of a challenge by judicial review. And this is simply to try and, I think, tie up a loose end and make clear that there's a coherence about all of this. And the amendment quite simply provides that where there can be a legal challenge to the referendum result by way of a judicial review, then Rule 30 should reflect the possibility of challenge under Section 31. And it's simply, as I say, to try and tie up what seems to be a loose end.
Will you move that as well?
Move, yeah.
Any other members that wish to speak? Deputy First Minister.
The bill as introduced states that the decision of the counting officer in any question relating to a ballot paper is final. This amendment, as Annabel Goldie has just outlined, explicitly provides that the decision of a counting officer is nonetheless subject to judicial review if that decision affects the number of ballot papers counted or votes cast. The bill makes provision for judicial review at section 31, and it's arguably implicit that this provision already covers the decisions of counting officers on ballot papers. However, in light of Annabel Goldie's opening remarks, I think she has persuaded me of the merits of this amendment. So for the third time this morning, I'm happy to support Annabel Goldie's amendment in the interest of making sure the bill is absolutely clear on this issue.
This experience is innovatory and refreshing.
Probably won't last.
Winding up.
Indeed.
That's exactly the question is that Amendment 29 be agreed to. Are we all agreed? The question is that Schedule 3 be agreed to. Are we all agreed? The question is that Section 10 be agreed to. Are we all agreed? I call Amendment 112 in the name of Lewis MacDonald, grouped with Amendments 113, 114 and 30. Lewis MacDonald to move Amendment 112 and speak to all amendments in the group.
Thank you very much, Convener. It is in the nature of the referendum campaign that organisations will work together over the next few months that would ordinarily be working for very different objectives. The political parties in both Yes Scotland and Better Together are obvious examples of that. It's also reasonable to expect that ad hoc organisations will be formed to advance an argument on one side or the other of the campaign and will dissolve once the referendum is passed. What would not be reasonable, however, would be for either political parties or the designated lead organisation on either side, or indeed for anyone else, to form an organisation on its initiative simply to allow spending and campaigning to be done out with the limits imposed on the parent organisation by the terms of the bill. Such practice would clearly be contrary to the spirit of the proposed legislation, and these amendments are intended simply to ensure that it would also be contrary to the law. Our proposal here is that no one should be able to register as a permitted participant who is already a director, an employee or a contractor of another such permitted participant, and that no organisation should be recognised as a permitted participant if it is mainly run or funded by another such body or shares with that body its primary decision maker. These restrictions do not prevent bodies from working together to a common plan, as the bill already provides for this, and we will seek to strengthen and clarify that provision. What they do seek is to remove any temptation for campaigners either to increase their spending opportunities or to mislead voters about the breadth of their support by setting up bodies which actually have no independent existence but are registered as if they did. The committee recognised these concerns at stage one. I know that members took the general view that public scrutiny and the oversight of the Electoral Commission would help ensure that any front organisations either were not set up at all or were dissolved as soon as they were found out. I'm not sure, Convener, that experience elsewhere suggests that that will necessarily be the case. Public scrutiny and oversight may not be enough on their own. That's surely particularly true in a referendum on a profound constitutional change. Any penalties exacted after the event will certainly pale into insignificance compared with what is at stake for both sides. When the referendum group No to AV gave their evidence at stage one, they supported a general approach similar to that of these amendments. They identified that the objective of the common plan provisions in the bill was to prevent evasion of spending limits by the creation of what they called dummy organisations. They argued it would be far easier and more effective for the Electoral Commission to prevent evasion if it were able to reject registration by such organisations than if it could only seek to detect and penalise abuse after the event. For that reason, they recommended that there should be amendments to this part of the bill, and that is what we propose today. And I move Amendment 112 in my name.
Thank you, Lewis MacDonald. Deputy First Minister to speak to Amendment 30 and other amendments in the group.
Thanks, Convener. I acknowledge the intention behind Lewis MacDonald's amendment and have some sympathy for what he's trying to achieve here. I can't support these amendments for reasons I will outline, and then I'll outline the reasoning behind my own amendment. The Edinburgh Agreement confirmed that the regulations for the independence referendum campaign should be based, as far as it's possible, on existing UK legislation for elections and referendums. Amendments 112, 113 and 114 would depart from the PPERA regime in a way that I think is untested. For example, it's not clear what the consequences of such changes would be, particularly around defining managerial responsibilities or decision-making on behalf of a body. Therefore, I would have concerns that these amendments could lead to unforeseen and unintended consequences, and for those reasons I would ask the committee to reject Lewis MacDonald's amendments. However, as I said, I do have some sympathy with the intention behind these amendments, and while the committee has said that it's generally satisfied with the rules regarding campaigners working together, I acknowledge that concerns have been expressed by some members about the possibility of a campaigner or an individual setting up multiple campaigns which appear to be separate organisations but are in fact run by the same people with the intention of circumventing spending limits. You know, it's absolutely right that anybody who wishes to participate in the debate should be able to do so. Indeed, they should be encouraged to do so. But it's also important to have robust controls in place to ensure that campaigning activity is seen to be fair. The bill already provides for circumstances where campaigners are working to a common plan to prevent campaigners from setting up separate organisations to increase their spending capability. So I hope that Lewis MacDonald will be reassured to some extent by the Government's Amendment 30, which will ensure that each registered campaigner has a different responsible person and which will make it harder for a single campaigner to try to circumvent spending limits by establishing multiple campaign groups. This amendment is based on a similar provision made in the enabling legislation for the referendum on the parliamentary voting system in 2011 and has been recommended by the Electoral Commission. So with these remarks, I would ask the committee to support Amendment 30 and, albeit recognising the good intentions behind them, to reject Amendments 112, 113 and 114.
David Scott.
Yeah, can I thank you, Convener. Firstly, recognise the tone of the Deputy First Minister's remarks in this area. I believe Lewis MacDonald has come up with a decent stab at an issue that we did deal with quite extensively in committee evidence earlier in the summer. I think that's a reasonable effort on that. I, at that time, expressed my concern about the, as it were, court of public opinion being the test as to how this would be scrutinised, and I think if we are all again all being objective about it, as Lewis MacDonald has indicated, in the aftermath of whatever happens next September, I suspect that and the penalty regime that is envisaged in this legislation will be hardly here nor there. So there does appear to me to be the balance of the argument that does appear to me to support some tightening of these rules and therefore of the law. And I think these amendments do go some way towards what we did, after all, tease out in evidence.
Annabel Ewing.
Thank you, Convener. I take a different view. I recall well the discussions we had in earlier sessions on this issue. I think it is important to note that the Electoral Commission support the provisions of the bill as currently drafted in this respect, and therefore that would serve to indicate they don't support the amendments being put forward by Mr MacDonald. I do recall that Mr MacDonald himself put forward a submission to the Scottish Government's consultation on the referendum, where he said that it should be for the Electoral Commission to not only set the limits on the expenditure, but also the rules of conduct for the campaigns. And I think that is the way to proceed. I think he was absolutely right in his earlier submission to the Scottish Government, and therefore I don't quite see why he has changed his position on that. I certainly welcome the Deputy First Minister's amendment this morning, which would indeed make it harder to circumvent the rules, and I would therefore support that amendment, but I cannot support the amendments of Mr MacDonald.
Patrick Harvey.
I wonder if I could ask if Lewis MacDonald, when he's winding up on this group, might indicate whether this is the only approach to the issue that he considered, or whether he thinks there may be other ways that the same issue could be addressed. I'm minded to reserve my judgment on the amendments that are in front of us at the moment, but I think I would welcome an indication as to whether Lewis MacDonald is open to other variations on this theme as we move on.
Else? Is there anything you want to deal with any of that. I'm not sure there's anything new emerged, so I'll just... Oh, sorry, Anna Magoli. Apologies.
Very briefly, Convener. Initially, I thought maybe Mr MacDonald was being a little fussy. But then when it comes to fussiness, I'm the epitome of the weed. So I was looking at them more closely in the context of the schedule. And I have to say, I think he's got a point. And I think it does. There is a little gap within the text and the phrasing of the schedule. And I am minded to think this helps. And I propose then to support the amendments.
Which case, we've got Lewis MacDonald to wind up and press a withdrawal.
Thank you very much, Convener. I'm grateful for the comments from the Minister and from members, and of course I do welcome Amendment 30 and will support that. I do see it as a step in the right direction, however, not an adequate step, and I think that's why I've brought these amendments forward today. Annabel Ewing rightly says that the general approach that I have favoured, and indeed my party colleagues have favoured, is one where the Electoral Commission should set the parameters within which Parliament legislates. However, it is finally for Parliament to legislate. And I think these amendments do strike the right balance because they are not punitive. And Patrick Harvey asked, had I considered other possible approaches? I think the consideration that I had suggested that this approach was the right one. The question was, at which level should there be a debar imposed? And a debar, if you like, at the level of 50% seemed to me to be a sensible compromise. Any organisation that's funded by more than 50% is clearly not a wholly independent organisation. It may be argued that an organisation funded at 40% is not likely to be wholly independent either, but in recognition of the need to seek compromise and to seek to meet the views of colleagues around the table, I think 50% struck me as a good way to a good point at which to pitch this. The Deputy First Minister said, well, there might be consequences here in terms of the definition of what was managerial responsibility, what was the principal decision maker. I mean, clearly those issues are raised by any set of amendments in this sort of territory. I would invite the Deputy First Minister and indeed members of the committee to accept that these amendments take us forward, but if the Deputy First Minister or indeed the Electoral Commission have any particular points they wish to clarify, there would be no difficulty in amendments coming forward at stage 3, and certainly if these amendments were passed at this stage, I'm sure I and others would be very open to discussion around how to further refine them in order to ensure that they achieve their objective and no more than their objective. But I do think the issue of openness and transparency has to be absolutely at the top of our agenda as a committee and as a Parliament, and it's for that reason that I will press these amendments.
Thank you, Lewis. The question, therefore, is Amendment 112 be agreed to or well agreed? No. Okay, in that case, we'll proceed to the vote. Those in favour, please show. Okay, thank you. Those against? Those abstaining? Those in favour 6. Those, sorry, 4. Those against 6. That would have caused an interesting situation. And those abstaining 1. Therefore, the amendment is disagreed to. I call Amendment 113 in the name of Lewis MacDonald, already debated with 112. Lewis MacDonald to move or not move. Moved. The question, therefore, is that Amendment 13 be agreed to or well agreed. No. 113 is what I said. There was a no, and therefore we therefore go to the vote. Therefore, those in favour, please show. Those against? Those abstaining? The number in favour 4, the number against 6, the number abstaining 1. Therefore, the amendment is disagreed to. I call Amendment 114 in the name of Lewis MacDonald, already debated with Amendment 112. Moved. Lewis moved. Okay, we move to the vote. Those in favour, please show. Those against? And those abstaining? Number in favour, 4. Number against, 6. Number abstaining, 1. Therefore, the amendment is disagreed to. The question is that Amendment 114 be agreed to or well agreed. Sorry, apologies. Just try again. Call Amendment 30 in the name of the Deputy First Minister, already debated with Amendment 112. Deputy First Minister, to move formally.
Moved.
The question is that Amendment 30 be agreed to or well agreed. Yes. I now call Amendment 31 in the name of the Deputy First Minister, group with Amendments 32 and 33. Deputy First Minister to move Amendment 31 and speak to all amendments in the group.
The timetable for designation of lead campaigners currently provided for in the bill is the same as that set out in PEPERA. It provides that applications for designation must be made within the first 28 days of the referendum period and a decision made by the Electoral Commission within a further 14 days. However, that means that it could be 6 weeks into the 16-week referendum period before the designated organisations are confirmed. Subject to parliamentary approval of the bill, there will of course be a longer period between the enactment of the bill and the start of the referendum period than has typically been the case for PEPERA referendums. In light of this and the fact that referendum campaigning is already well underway, the Electoral Commission has recommended that it would be beneficial to decouple the designation process from the start of the referendum period. In this case, we and indeed the Commission think a minor adjustment to the PEPERA approach is justified. Bringing forward designation will do a number of things. It will provide earlier certainty to campaigners and voters about the identity of lead campaigners. It will enable those lead campaigners to make effective use of the benefits available to them during the whole 16-week referendum period. It might help facilitate collaboration between the lead campaigners and other campaigners to ensure consistent messages to voters, and it will of course give the Electoral Commission more time to consider alternative arrangements in the event that it's unable to designate for one or both outcomes. I note that the committee agreed with this approach in its Stage 1 report. On the basis of the discussions we've had with the Electoral Commission, these amendments provide for designation to be confirmed around a month before the start of the referendum period, and that will allow sufficient time for the benefits of early designation to be realised while avoiding any potential risks associated with designating too far in advance of the referendum period. With the referendum taking place on the 18th of September, applications for designation will therefore have to be submitted in the period between Thursday the 20th of March next year and Wednesday the 16th of April. The Electoral Commission will have to make its decision between Thursday the 17th of April and Friday the 2nd of May. So I hope that the committee agrees that this strikes a reasonable balance, and I move Amendment 31.
And no one else wish to contribute in this particular set of amendments? Okay. Deputy First Minister, you won't wish to wind up in these circumstances. The question is therefore that Amendment 31 be agreed to or well agreed. I now call Amendment 32 in the name of the Deputy First Minister, already debated with Amendment 31. Deputy First Minister to move formally.
Moved.
The question is Amendment 32 be agreed to or well agreed. I call Amendment 33 in the name of the Deputy First Minister, already debated with Amendment 31. Deputy First Minister to move formally.
Moved.
The question is that Amendment 33 be agreed to or well agreed. Okay, I now call Amendment 34 in the name of the Deputy First Minister, grouped with Amendments 35, 36, 37, 38 and 39. Deputy First Minister to move Amendment 34 and to speak to all other amendments in the group.
Thanks, Convener. These amendments relate to the campaign rules dealing with payment and return of referendum expenses. Amendments 34 and 38 are minor technical amendments to the drafting of the provisions on the payment of late claims in respect of referendum expenses in line with the Electoral Commission's recommendations. As a result of Amendment 34, it will be for the Electoral Commission to determine if late claims may be paid without referring to any special reason. Amendment 38 simplifies the process for a permitted participant who has been granted leave to pay a late claim. Amendments 35 to 37 relate to the Electoral Commission's power to appoint an auditor to report on referendum expenses in certain circumstances. The bill provides that where a permitted participant's referendum expenditure exceeds £250,000, they must provide an auditor's report with their expense return. Given the spending limits in the bill, this requirement will only apply to the 3 largest registered parties and to designated organisations. The bill gives the Commission power to appoint an auditor if it appears that the permitted participant has not done so within 3 months of the end of the referendum period. The Commission has suggested to us that this power should be removed, as they would not be able to confirm that an audit is needed until the expense return has been submitted, and this is not a power currently available to the Commission under PEPERA. Amendment 35 accordingly removes that power. Where the Commission is aware that an audit is required but has not been carried out, it may impose a compliance notice under paragraph 3, subsection 1b of Schedule 5 to require one to be undertaken. In addition, failure to deliver the audit return is an offence to which civil sanctions will apply, subject to the Committee's and the Parliament's approval of the relevant amendments. Amendments 36 and 37 are consequential in Amendment 35, and these minor amendments will bring the provisions more closely in line with PEPERA. The bill currently provides that when a permitted participant submits the referendum expenses return, they must include a declaration confirming that all relevant donations received are from permissible donors, or if not, that they've been handled according to the provisions relating to impermissible donations. On the Electoral Commission's recommendations, this amendment replaces the reference to received donations with a reference to donations that have been accepted. The intended purpose of the declaration is to encourage permitted participants to pay particular attention to the accuracy of the return and confirm that accepted donations are indeed from permissible donors, or if it's been discovered that an impermissible donation has been mistakenly accepted, that it has been handled correctly. This serves as a reminder to check the permissibility of donations declared as accepted. So given that these amendments are in line with Electoral Commission recommendations, I hope that the committee will feel able to support them, and I move Amendment 34.
Thank you much. Any other member wish to contribute? Deputy First Minister, I don't think we'll wish to wind up in these circumstances. The question therefore is that Amendment 34 be agreed to or well agreed. I now call Amendment 115 in the name of Drew Smith, grouped with Amendment 116. Drew Smith to move Amendment 115 and speak to both amendments in the group.
Thank you very much, Convener. Amendments 115 and 116 are a reasonably simple change to the level of spend by an individual or group, which would trigger registration and which simply substitute the figure of £7,500 in place of the figure of £10,000, which is in the bill as currently drafted. And there are really two elements to this. The first is that the committee did hear, I think, general evidence about the level of donations and spend which should trigger reporting or registration. And broadly speaking, requiring registration or reporting of lower amounts of money donated or spent is more transparent, since the public can therefore see the origin of more of the money which is spent in a campaign. That said, though, there is always a balance to be struck between transparency and practicality for campaign groups, and it's therefore not my intention to discourage donations or spending, since I think, as the Deputy First Minister said in an earlier group, people have the right to campaign and the public have a requirement for information which we recognise does cost money. So in reducing the level at which spend should lead to registration, I'm seeking to aid transparency without creating a new level which would in practice discourage spend or be too onerous on campaign administrators. So if we agree that a lower trigger point aids transparency, but it should not be so low as to be administratively cumbersome, the question then is, what is that figure? And the reason that I have chosen 7,500 in this amendment as a new level at which spend should trigger registration is, I think, a good and logical one, because the bill already provides that donations to a campaign should be declared at 7,500, and that reflects provisions elsewhere in electoral law. So if our view is that the public should be made aware of when a campaign benefits from a donation of 7,500, then I think it's somewhat anomalous that spending that amount of money rather than donating it to someone else should not be transparent at the same level. So put simply, if donating 7,500 to someone else triggers transparency provisions, then spend of 7,500 yourself should do the same, and I move Amendment 115.
Okay, who else wishes to contribute in this bit? Stuart McMillan.
Thank you, Convener. Just as Drew Smith mentioned there, the issue of the balance of transparency, and I'm conscious that certainly in our Stage 1 report, obviously this point came up, and certainly in the Stage 1 report, Page 34, paragraph 182, we comment on this particular point, and we agree certainly with the Electoral Commission's recommendations that £10,000 should actually be should be the limit, and certainly in the Electoral Commission's advice regarding the referendum bill, paragraph 1.8. They suggest that they were recommending a spending threshold for registration as a campaigner of £10,000. So certainly, I mean, this committee certainly took the advice of the Electoral Commission that the £10,000 actually was a legitimate sum of money. And kind of one other point, I mean, that Drew Smith commented there regarding the lower of the threshold, it wouldn't create a kind of a cumbersome administrative burden. If it were to be reduced, actually, I mean, I believe that certainly for smaller organisations who actually do want to participate in the referendum, then reducing it to £7,500 probably would actually create an additional layer of bureaucracy for smaller organisations. So, for that matter, it's, I would certainly, I'm not really kind of minded to support the reduction down to the £7,500.
Anyone else wish to contribute? Well, I'd like to say a couple of words on this particular one, because it strikes me all the way through this process we've used the Electoral Commission as our guide in terms of what we would how we would act as a committee. That would be our starting point, and unless something significant was to come along, we shouldn't be unpicking what the Electoral Commission is doing. Otherwise, effectively, we'd be cherry-picking elements of the Electoral Commission's advice to us in a way which was never expected at the beginning of the process, because I think all parties accepted the advice provided by the Electoral Commission at the beginning of the process. Indeed, my recollection is that that all parties were encouraging each other to do exactly that, and therefore to start cherry-picking now at this stage and begin to unpick the rules on which elements we can and cannot support from the Electoral Commission, given particularly the evidence that we took during the committee process, I think would be certainly difficult in principle at this stage. Patrick.
Thank you, Convener. Just briefly, in relation to the general point about the acceptance of Electoral Commission recommendations, it seems to me that in this context, in the context of a reporting threshold, increasing that threshold would seem to be a rejection of the Electoral Commission's recommendation. That would seem to fly in the face of a recommendation about a reporting threshold like this, whereas reducing it seems to me to do the opposite, to come within what has been recommended rather than to breach what has been recommended. And I'm minded at the moment to support the amendment unless I hear a compelling case against it from the Deputy First Minister.
Davish.
Yeah, thank you. I wasn't going to say anything until you made that passionate defence of the Electoral Commission, and I absolutely take your point up to a point, and that is that surely legislators have a responsibility, of course, to assess in this case, the limits, or in this case, the arguments made by an independent body, and yes, to take Stuart Miller's point, of course, to reflect on the evidence that was provided at that time. But I think Drew Smith has made a reasoned argument which Patrick Harvey's just extended, in terms of our ability as legislators to make an assessment of that. And I think all I ask, I take the convener's point about cherry-picking, but I do think it's reasonable for legislators to say, look, there's a consistency argument here, and to at least apply that. I think it would be quite difficult for the Electoral Commission to be against a consistency argument, particularly in the context of Patrick Harvey's remarks.
Lewis.
Thank you very much. I think, again, I would reflect on the fact that we had a debate earlier this morning on postal and proxy voting, where the Scottish Government and the majority of the committee chose to take a different approach to postal and proxy voting from the recommendations to the Electoral Commission. That's entirely legitimate, but it's equally legitimate to do as Patrick Harvey says, and that is to implement the wishes of the Electoral Commission, except more so, and except in a way that exposes an inconsistency that I think Drew Smith articulated very clearly, and I think his amendments do allow us to address that inconsistency.
Stuart Maxwell.
I mean, I accept what Drew Smith's saying in terms of the fact that we have, there's always a question about balancing these things, and we could argue about around these figures. But I have to say, I think the point that Lewis just made is that about departing in areas from Electoral Commission recommendations. I think we've been very careful throughout this process that where we have departed from Electoral Commission, it is for very, very good reason. And I think that is the important point here. On this, the recommendation is £10,000. I want to just clarify something. I don't know if the Deputy First Minister can do this, or even Drew Smith when he winds up. My recollection is that the PEPERA rules are that it's £10,000 in this area, and I just wanted to know if that was the case, if any of the members could clarify that. Again, that would be another departure. If we're departing from the Electoral Commission recommendation and the PEPERA rules, I think we'd have to have very good reason for doing so, and I would suggest that we don't have that at this stage.
And we'll go there.
I'd just like to say that I think the Electoral Commission's role in all of this is pivotal, and we all acknowledge that. And I think the Electoral Commission's general role is one of advice and protection of the public interest. And it seems to me that what is proposed in these two amendments is actually to tighten the public interest, to make more specific what that protection is, and also, as was pointed out in the comments supporting the amendments, to achieve a consistency in the bill. And I do think it is important. I mean, intellectually, I can't see why, if a certain figure is considered appropriate in terms of reporting requirements, if it's a donation to one of the campaign groupings, then why shouldn't that cover the activity of an individual? And I think there is a compelling logic about that. And I don't think agreeing to this in any way impugns the Electoral Commission. I don't. I mean, I think the Electoral Commission, look, we put a figure, we put it forward, but at the end of the day, you're the politicians, and if there is an inconsistency in the bill, you make a judgment about whether or not to address that. And I'm attracted to addressing the inconsistency, and I think to address it, frankly, is not prejudicial, dangerous, risky. I think it's helpful.
Anybody else wish to contribute? In which case, I'll go to the Deputy First Minister.
I find these amendments in the debate we've just had just a little bit ironic, actually, because members will, I'm sure, be aware, I'm sure they will recall with great clarity that when the government first issued a bill for consultation, we actually proposed a threshold for registration as a campaigner of £5,000, but the Commission then published its recommendations on spending limits where they considered that that was too low and specifically recommended a threshold of £10,000. So I'm not sure, with the greatest respect to Patrick, that he's right to say that moving downwards as opposed to be upwards would be staying within the spirit of the Electoral Commission's recommendations, because they deemed the, albeit lower than 7,500 initial recommendation of the Scottish Government was too low. The irony, I suppose, I'm finding in all this comes from the fact that before the Electoral Commission published their recommendations, I recall very, very clearly being told in no uncertain terms by Drew Smith's party that any departure on the part of the Scottish Government from the Electoral Commission's recommendations, specifically on spending limits, I seem to recall, would be completely unacceptable and outrageous. And of course, the Scottish Government didn't depart from the Electoral Commission's recommendations. We accepted them in full, and they are reflected in full in this bill. The Commission stated that based on evidence from previous elections and referendums, and in light of the Commission's recommended maximum spending limits for different types of campaigners, it could see no reason for departing from the PEPERA registration threshold. And I think this is an important point to make. If we were to pass these amendments, we wouldn't just be departing from the Electoral Commission recommendation. Stuart Maxwell is absolutely right. We would be departing from the thresholds that are laid down for other referendums in PEPERA. So I would argue very strongly that far from addressing an inconsistency, which some members have suggested that these amendments would do, we would be creating an inconsistency with the rules that are in place for other referendums. And, you know, having been encouraged to, in the strongest possible terms, and having taken the decision to accept the Electoral Commission's recommendations, having started from a much lower point than Drew Smith's amendments, I think it would be rather strange at this point, in the absence of any good argument, to go against PEPERA and to go against the Electoral Commission. A lower threshold would create a larger administrative burden for smaller local campaigners, which I think it is important at this stage to avoid. A £10,000 threshold will, I think, allow us to ensure robust expenditure controls while reducing the risk of inadvertent non-compliance and therefore helping voters to engage with the debate without unnecessary barriers. So for all of these reasons, including my desire at all times to follow the advice of the opposition and stay consistent and follow the advice of the Electoral Commission, I would ask members to reject Drew Smith's amendments.
Thank you, Deputy First Minister. Drew Smith.
Thank you very much, Convener. I'm always happy to surprise the Deputy First Minister with an attempt at compromise. And I mean, I think based on the debate, I mean, I don't think the argument about departure from the Electoral Commission flies, but I think there is an issue here about the illogicality of saying if you provide £7,500 to another organisation, Better Together, Yes Scotland, whoever, the public needs to know that you have done that because you are influencing the debate and there is a need for transparency around that. But if you spend that money yourself or set up your own campaign and spend the same amount of money, then that is absolutely fine. So I think that is the inconsistency that these amendments address. I don't think there was any disagreement in the discussion that, in general terms, reducing the levels of spend where we would require registration do promote transparency, and I don't feel that a clear argument was made as to why the difference between 7.5 and 10 would be administratively onerous on any of the campaigns, and I would therefore intend to press the amendment. Convener.
Thank you, Drew Smith. The question, therefore, is that Amendment 115 be agreed to or well agreed? No. Yes. In which case, we'll go to a vote. Those in favour, please show. Those against? Those who abstain? Those in favour, therefore 5. Those against 6. Therefore, the amendment is disagreed to. We now move to call Amendment 1 in the name of Patrick Harvey, group with Amendment 2. Patrick Harvey to move Amendment 1 and to speak to both amendments in the group.
Thank you, Convener. These two amendments relate to some of the arguments that we've heard in relation to other groups around the possibility of common plans and cooperation between groups, and the fear or concern that that could be used as a tactic to circumvent spending limits. This was debated in the Chamber at stage 1, and I had an exchange with, I think it was James Kelly at that point, trying to make the argument that that concern, in some way should be sharper in relation to small bodies than it is in relation to large ones, and in particular to the designated organisations. Paragraph 19 of Schedule 4 is not about the spending limits. It's about how expenses are declared when they're part of a common plan, and in particular, Section 2 of that paragraph requires that where there is a common plan involving, in this case my concern is small organisations, expenses have to be declared as having been incurred by both, when in fact they've only actually been spent once. Now I can see at some point why there's a case in favour of that, but my concern is that small organisations or individuals may find themselves breaching a threshold, breaching a reporting threshold, committing an offence inadvertently, not because they have in fact spent more money than they're supposed to, but because they've been involved in a common plan and had a reporting requirement that they may not have been aware of. And I would suggest that, for example, if an individual or a small community group or a small political party, one that isn't given its own spending limit in the legislation, was, for example, to run a website or a series of public meetings and spend a very small amount of money on that, but a larger organisation which was expecting to breach the £10,000 threshold was to publicise that website or the public meetings that they were being organised, and was to spend large amounts of money on a postal campaign or a paid advertising campaign. It could be that the individual or the very small organisation is actually required to declare, perhaps very late on in the campaign, spending that they'd never intended to incur, and in fact which they hadn't in fact incurred. They hadn't actually spent that money. They're just expected to report it as though they had, as though the money had been spent twice. So my amendment number 1 removes the reference to paragraph 17 in this. And so it removes the possibility that a small organisation or individual in this situation would be committing an offence. And Amendment 2 says that this paragraph 19 would then apply where any of the individuals or bodies involved in the arrangement was a permitted participant. And so, again, it removes the application to those which are not, those which don't intend and don't have any realistic expectation of breaching this £10,000 threshold. Now, it may be that there are good arguments against this, but even if there are, I would ask the Deputy First Minister in responding to reflect on the situation I'm suggesting, where we still don't yet know what the real definition and rules of what a common plan looks like, what counts as a common plan. What is the situation of an individual or a very small organisation which finds itself at the last minute, perhaps, expected to report as though they'd spent a large amount of money which was actually spent by somebody else, and finding that they've broken the law entirely unintentionally, not through actually spending more money than they're supposed to, but by incurring a requirement to report it as though they had. And I move Amendment 1. Okay.
Any other members wish to? Stuart Maxwell.
It's more of a question, really, than to Patrick Harvey. I was very interested in what Patrick Harvey was saying there, and I think he makes an interesting point. But I'm slightly puzzled by what his definition is of small, because he mentioned an individual, a small community group, and actually I think he said political party as well at one point, small political party. That's quite a range of definition for small. So it could he perhaps, when he's summing up, actually define what he means by small, because I think in terms of these amendments, that's quite an important point.
Lewis MacDonald.
Thank you very much, Convener. I think my concern here is not with what Patrick Harvey's intention is. I hear very clearly what he says. My concern is that the real dichotomy here is not between large organisations and small ones. It's between registered participants and unregistered participants. And I think experience elsewhere suggests that if participants who are not registered are able to play a large role in a referendum campaign, they can have a large influence on the outcome, even if they are in themselves technically small organisations. And I think it comes back to some of the discussions we've already had this morning about the importance of transparency in who spends what and on whose behalf. Because although I understand what Patrick Harvey is seeking to achieve, the effect of his amendments, apparently to assist small organisations, as he puts it, actually enables what you might call large organisations or permitted participants to use non-registered participants more easily as a channel for spending money. And therefore, while I know that's not Patrick Harvey's intention, I think that is the concern, that it might be open to abuse in that way, and therefore on those grounds I would be not inclined to support the amendments in his name.
Is there anyone else wish to contribute? Deputy First Minister?
I think, like others, I've got a lot of sympathy with the principles and the intentions underpinning Patrick Harvey's amendments. The campaign regulations in the bill are designed to ensure that expenditure controls are fair, they're transparent, they command the confidence of both sides of the debate, on the one hand, but on the other hand, to ensure that they're not overly burdensome to smaller campaigners who are only intending to spend a small amount of money, or who'll be making only a small contribution to the work of another campaigner. And it's important that we try to strike the right balance there, but doing that is not completely easy. I mean, these are pretty complex provisions, and I think we need to be quite careful that we don't make piecemeal changes that could have unintended consequences. I absolutely accept that Patrick Harvey's amendments would act to avoid an individual or a small community group inadvertently breaching reporting regulations, but I also think Lewis MacDonald is absolutely right. At the other end of the spectrum, there is a danger that they open up a loophole for an organisation that would otherwise campaign and report as an organisation and as a registered permitted participant, almost being encouraged to campaign instead as a group of smaller individuals, all of whom can stay under the limit and therefore not be obliged to register or to report. But the totality of their campaigning influence is exactly the same as it would be if they were a bigger organisation. I hope to kind of recommend maybe a compromise at this stage, because I recognise there is perhaps more work to be done around this. My officials are meeting tomorrow with the Electoral Commission to discuss how common plans are going to be handled in the Commission's guidance, and to try to ensure that the bill achieves the policy intention in a way that is both clear and practicable and avoids unintended consequences. And I'm happy that these proposed amendments for the bill would form part of that discussion, and I can then report back both to Patrick Harvey and the committee on the outcome of these discussions ahead of stage 2, to allow an informed decision to be made by him about whether he would want to resubmit them at stage 3, or indeed whether there's other amendments that we could agree on that would meet these principles and intentions in a better way. So I would ask Patrick Harvey today to not press these amendments, to allow for that further discussion, and either for us to be collectively satisfied that the Commission's guidance will deal with these points, or have amendments coming forward at stage 3.
Patrick Harvey.
Can I thank members for the debate? And I think it's fair to recognise that there is a tricky balancing act to strike between not overburdening people or placing people in the position where they may inadvertently and entirely innocently find themselves having committed an offence, perhaps even without knowing so, and on the other hand preventing genuine attempts to subvert the rules or to find workarounds. In terms of what is small, clearly the effect of the amendment is the threshold, the spending threshold that's in paragraph 17. I haven't attempted to define small in any other way, although Stuart Maxwell talked about the reference I made to political parties. There are some very small political parties that spend, a few tens or hundreds of pounds a year, rather than the range of small to large parties that exist in this Parliament. There are some very small political parties which will also want to campaign, and I still have a concern that some organisations like that, or of that scale, might find themselves being required to report expenditure that they hadn't actually had made themselves, but had been made by a larger organisation, which can be expected to know what the rules are and have to report and register as a permitted participant. Clearly, I'm not asking for unregistered organisations to play a larger role or to be allowed to spend more money, but simply a question about what the reporting requirements are. Having said that, I'm very grateful for the Deputy First Minister indicating that there's some scope to discuss this further. It may well be that these amendments are not the best way of addressing the issue. I do hope that there's another way of addressing that can be found. So, having said that, I'd like to ask leave to withdraw Amendment 1.
Okay, does anyone have any objection to the amendment being withdrawn? Okay, thank you very much. In which case, we'll now move on to call Amendment 2 in the name of Patrick Harvey. I already debated with Amendment 1. Patrick, to move or not? Not moved. Thank you. I now call Amendment 116 in the name of Drew Smith. Already debated with Amendment 115. Drew Smith, to move or not to move?
Not moved, Convener.
Okay, thank you. The question, therefore, is that Amendment 106... No, I don't need to do that bit, you're right. Call Amendments 35, 36, 37, 38 and 39, all in the name of the Deputy First Minister and all previously debated. I invite the Deputy First Minister to move Amendments 35 to 39 en bloc.
Moved.
I ask, therefore, whether any member objects to a single question being put on these amendments. With no objection, therefore, I put the question. The question, therefore, is that Amendments 35 to 39 be agreed to. Are we all agreed? Agreed. Thank you. That ends proceedings at this stage, as we had previously indicated. Stage 1 will obviously come back next week, and members are, of course, entitled to lodge further amendments, Stage 2 amendments on any parts of the bill not dealt with today, and the deadline for lodging such amendments is 12 noon on the Monday, the 7th of October, and the next meeting is scheduled for the Thursday, the 10th of October, where the committee will consider the bill again at Stage 2, our second day. Thank the Deputy First Minister and officials and members of the committee for attendance today. Thank you very much. I close this meeting.